This presentation will cover the fundamentals of estate planning. We're not going to examine every potential estate planning option, pitfall, and every available solution to those pitfalls. Rather, we have three basic objectives for today. First, we will define, and perhaps for some of you, redefine what estate planning is. Second, we will review what the basic estate planning documents are. And third, we will discuss what probate is and the process when no estate plan is completed. But first, a disclaimer. This presentation does not constitute legal, accounting, or other professional advice. Only through personal, confidential consultation with qualified legal counsel can anyone properly evaluate their own unique planning challenges and determine what, if any, appropriate legal strategies and tactics should be implemented to meet those challenges. What is estate planning? First, let's consider what estate planning is not. Estate planning is not death planning merely for the distribution of one's assets after their lifetime. Rather, estate planning is a lifetime process concerned chiefly with the control and protection of one's assets during life and the passage of assets after death. Let's take a look at some relevant statistics. A recent Caring.com survey determined that only 42% of U.S. adults currently have estate planning documents, such as a will or a living trust. For those with children under the age of 18, the figure is even lower at just 36%. So as you can see, you're not alone if you haven't done an estate plan. Of those 42% that have an estate plan, many estate plans are either out of date or completely inappropriate for the person's goals and objectives. In fact, in some instances, having an out-of-date or inappropriate plan can be worse than having no plan at all. If the plan is current and accurate, that's wonderful. Estate planning is a lifetime process, and it is important to review your plan periodically to keep it current with the changes in your life, your assets, your family and beneficiaries, and the ever-changing law. Now let's discuss what a basic estate plan consists of. During life, the following documents are necessary should you become incapacitated. First, an advance healthcare directive. An advance healthcare directive is a document in which you detail who will make medical decisions and what decisions you want should you become incapacitated. An advance healthcare directive also provides evidence of your wishes regarding various life-prolonging medical procedures or techniques when you are unable to communicate your own wishes. You see, the law says that every adult American is responsible for their own personal, health, and financial decisions. But what happens if a stroke, a car wreck, or dementia leaves you disabled to the point of legal incapacity? Who will make your decisions for you? If you have created an advance healthcare directive, part of your plan is in place. If you have no plan, then your loved ones will have to petition the probate court to be able to make medical decisions as well as end-of-life decisions for you. This is known as a conservatorship of the person in California and is the default plan for people who have failed to plan and create advance healthcare directives. This process involves legal proceedings that can be expensive, require full disclosure of your very private and confidential personal healthcare matters. Ultimately, through the process, you and the decision maker appointed for you by the court will be placed under an ongoing supervision of a probate judge who likely doesn't even know you or your desires. The second document during your lifetime that we recommend is a durable power of attorney. A durable power of attorney is a document in which you detail who will make your financial decisions and what decisions you want should you ever become incapacitated. The durable power of attorney allows your appointed decision makers broad authority to handle such financial matters as depositing checks on your behalf and filing your tax returns for you. The durable power of attorney is a separate document from the advanced healthcare directive. You may even choose to name a different person for your financial decisions than the one you've named to make your healthcare decisions. If you don't have a durable power of attorney and you become incapacitated, then your loved ones will have to petition the probate court to be able to make financial decisions for you. This procedure is known as a conservatorship of the estate in California, and it's the default plan for people who have failed to provide for their financial decisions during life. Like a conservatorship with a person, this process involves legal proceedings that can be expensive, require full disclosure of your very private and confidential financial matters. Ultimately, you and the decision maker appointed for you will be placed under an ongoing supervision of a probate judge who likely doesn't even know you or your assets. The durable power of attorney is only effective during life, so additional planning is necessary to pass your assets at death. We will get to those documents in a moment. We also recommend that you have a HIPAA release. The Health Insurance Portability and Accountability Act provides protection for sensitive health care information. In your HIPAA release, you may designate people who may receive your protected health information. For example, your Advance Healthcare Directive agent and your agent under your power of attorney need to have access to your medical information to aid in the determination of whether you have become incapacitated to the extent that you are unable to manage your own health and financial decisions. In your HIPAA release, you may also choose to name additional family members or friends who will receive your protected health information. An Advance Healthcare Directive, durable power of attorney, and HIPAA releases are essential for any American over the age of 18. It's your life, and we want to make sure that you are making the decisions and putting safeguards in place should you become incapacitated, not leaving it up to a court. If you have minor children, it is a good idea to also create a guardian nomination for them. This document allows you to name backup parents for your children if you and their other parent are unable to care for them due to incapacity or death. Your nomination of guardians will allow you to give preference when you are unable to speak for yourself. Without the nomination, a judge will decide who will care for and raise your children without knowing anything about your goals, values, and preferences. In California, if you have assets valued at over $150,000, it's recommended that you also create a revocable living trust to provide for the care of your assets during your life and avoid probate at your death. A revocable living trust is a placeholder for your assets. It is not filed in the probate court, so no court involvement is necessary, and thus the trust protects your privacy from disclosure on the public record. When you are alive, you manage your assets as you would if you had no trust. If you become incapacitated, your successor trustee manages the trust assets for you in accordance with the terms of the trust. At death, your successor trustee administers your trust estate and distributes your assets as you have specified in your trust. Again, no court involvement is necessary since you've written out your wishes. A revocable living trust also gives you the flexibility in planning, especially if you have minor children, loved ones with special needs, or you need additional tax planning. Basically, it puts you in control. If your assets exceed $150,000 at death and are not held in your revocable trust, or do not pass automatically because of a beneficiary designation or other transfer method, those assets could be subject to probate. The last fundamental estate planning document we recommend is a will. Like a trust, after death your will can direct where your assets go. However, unlike a revocable living trust, your will is only effective after you die, and it is admitted to probate. When used in conjunction with a revocable living trust, the will is called a pour-over will, which means that any assets that go through probate are put into your revocable living trust and distributed according to the terms of that trust. We've been talking a lot about probate. What actually is probate? Probate is basically the default plan for the transfer of one's assets after the death with the assistance of the probate court. At your death, any assets that are titled in your name alone or which name your estate as a designated beneficiary upon your death likely will go through probate if the total value of those assets exceeds $150,000. If you have a will, your assets still go through probate, but they're distributed in accordance with the terms of your will. One commonly held estate planning myth is that a valid last will and testament will avoid probate. In reality, just the opposite is true. Your will has no legal effect until it is presented to and accepted by a probate judge. Think of it as your admission ticket to probate. If you have no will, then your assets go through probate and are distributed in accordance with the plan created for you by the state of California. Generally speaking, probate has 3 recognized disadvantages: unnecessary expenses, delays, and loss of privacy. These disadvantages may not outweigh the cost of probate avoidance, depending on your circumstances and applicable state law. Accordingly, you should consult with a qualified legal counsel to determine whether it is more advantageous or not to avoid probate at your death. Another important element of estate planning is determining whether estate tax will be due upon your death. In the United States, each person can pass $11,200,000 at his or her death estate tax-free. If a person's estate assets exceed that amount, the additional assets above the $11,200,000 limit could be subject to estate tax at a rate of 40%. Whether you have a trust, a will, or no plan at all, your estate can be subject to estate tax. With proper use of a trust, you can plan to reduce or even eliminate the estate tax in your estate and the estates of your beneficiaries. In essence, estate planning boils down to this. Proper estate planning includes protecting your assets from unnecessary loss while you are alive, as well as for your loved ones upon your death and the management of those assets when you cannot do so. Estate planning is not death planning merely for the distribution of assets, but rather planning during your lifetime. Planning is a lifetime process to protect your assets and keep you in control of what happens when you cannot make the day-to-day decisions. Your estate plan should change as you move through the different stages of life as your goals change. In closing, two things seem to doom many estate plans to failure. The first is good old-fashioned procrastination. That is why it is critical to stop delaying and make your plans now. If you already have an estate planning, the second danger lies in failing to maintain it on a regular basis. Everything from automobiles to relationships need ongoing maintenance. Your estate plan is no different. It's been a pleasure to be here with you today for our presentation entitled Estate Planning 101, Estate Planning Fundamentals. I welcome the opportunity to work with you to create your estate plan and maintain your existing plan. It's your life, so we want to make sure it's your plan. Thank you.